Oh, sorry. Dominique, let me know when we're live.
We're live.
Okay, let's go on the record on cause number 1-95912-9202 Sain LLC versus Abdel Hussein et al. Council, make your appearances.
Farah Ahmed for plaintiff and counter defendant 9202 Sain LLC.
Kal Hamida for defendant Abdul Hussein.
Mr. Bennett, you're muted.
Sorry about that. I'm Paul Bennett. I represent Ready Real Estate LLC. They're a third-party defendant and counterclaimant.
Mr. Blackman, what are you here for?
I'm general counsel for Sain, though Counselor Ahmed will be presenting.
Okay, great. Let's go ahead and proceed.
Thank you, Your Honor. As you know, Your Honor, we filed a no evidence summary judgment on 2 counterclaims that were asserted against us by defendant counterplaintiff Abdul Hussein, which are breach of contract and unjust enrichment. Your Honor, in this case, we've also filed objections to Mr. Hussein's summary judgment evidence. Would the court, we would like the court to address our objections first before we move on to our motions argument.
All right, yeah, go ahead and share. I'm going to let you share screen that. Go ahead and share screen.
Oh, sorry, Your Honor.
Go ahead and share screen, whatever objections you have.
Oh, okay, Your Honor. Let's see. Just a second, Your Honor. I'm just sharing the screen right now. Can everyone see? Okay.
Yep.
Okay. Your Honor, we're objecting to 3 pieces of evidence that are attached to Mr. Hussein's response, which is Exhibit A, his affidavit, Exhibit C, which are excerpts of his deposition transcript, and Exhibit E1, subpoena documents produced by non-party Baldwin Associates. The easiest one, Your Honor, that I would like to address first is Mr. Hussein's Exhibit C, which are excerpts of his deposition. Let me pull that up for you, Your Honor. We're objecting to this evidence, Your Honor, because it's not properly authenticated. As you can see, Your Honor, Exhibit C is lacking a cover page, and most importantly, the certificate.
I can't see it.
Oh, I apologize. Let me just stop the share and switch screens. Okay. Your Honor, can you see it now?
Yes.
Okay. So as you can see, Your Honor, Mr. Hussein's Exhibit C is lacking a cover page, as well as the certificate from the court reporter. It's just essentially page 42 and 38 and 34 of his deposition transcript. Therefore, it lacks authentication, Your Honor, and we object to, and we would like the court to strike that evidence.
Response?
Absolutely, Your Honor. I think she would like to strike all my evidence, but unfortunately there are rules. She's quoting the old rule, Your Honor, where we back then had to attach the actual certificate from the reporter. I think the law has been updated to where you can attach the actual deposition testimony incorporated by reference. And That's what we've done. We've attached the actual deposition. He is sworn, and I have sworn that these are actual excerpts from his deposition. I think that follows the current rules.
Your Honor, there's nowhere in Mr. Hussein's affidavit, which is Exhibit A of their response, where he, swears that these are true and correct copies of the transcript. I believe that Mr. Hamideh's affidavit, which is Exhibit E, he doesn't also testify that Exhibit C is a true and correct copy of Mr. Hussein's deposition transcript for May 27, 2020.
Objections overruled. What else do we have?
Thank you, Your Honor.
You want to get to the merits?
Let's see. We can get to the merits, Your Honor.
Okay.
So, Your Honor, as we mentioned, we've moved for summary judgment on on 3 of the elements of Mr. Hussein's counterclaim of breach of contract. We've established, Your Honor, there's no genuine issues of material fact to the second element, which is the plaintiff, which is Mr. Hussein performed or tendered performance. Element 3, which is 9202 Sain breached the sales contract. And the fourth and last element, which is that Mr. Hussein sustained damages as a result of a breach of the sales contract by my client, 9202 Sain. Mr. Hussein has failed to raise any genuine issues of material facts in support of those elements. He has not shown any evidence, Your Honor, or produced any evidence that supports that he's performed or tendered performance of the sales contract. In fact, actually, Your Honor, it's the opposite. Mr. Hussein, we initiated the suit against Mr. Hussein because he refused to appear at closing and consummate the sale of these 2 properties. He has not produced any evidence that shows that we breached the contract. In fact, he doesn't even point to anywhere in his response of a specific contractual obligation that was owed or due by us under the sales contract. And Your Honor, he hasn't produced any evidence that shows that Mr. Hussein has sustained damage as a result of a breach of contract by us.
Response?
Yes, Your Honor. I don't know where to start, but this is a total waste of the court's time. Your Honor, as you know, this is a form contract prepared by this seller, who is the seller, owner, and a real estate agent. In this sales contract, he lists himself as our agent, thereby having an absolute conflict of interest. In this sales contract, Your Honor, he has certain provisions that he has marked through without our consent. It doesn't have our initials. In this sales contract, he has certain provisions where he's initialed it just himself. There's other provisions that are written in that are not initialed by either side. The other just overwhelming, unenforceable provision is this 90-day provision that he wrote into the contract. He wrote into the contract, Your Honor, that my client would have 90 days from the date that he found out from the city of Dallas. Well, I'm going to misquote it, but basically the general theme of it is you've got 90 days to rezone from residential to commercial. And if you don't, within the 90 days, you can back out. But the contract doesn't say anything. And you aptly rule or mentioned the last time we had a hearing that provision is vague. I think it's vague. I think it's impossible to enforce. It doesn't say what would happen as what happened in this case. The city of Dallas ruled after the 90 days were over. My client, who has the equivalency of a 6th grade education in Arabic, not in English, was hoping that his real estate agent would at least protect his backside and inform him and advise him what to do. To the contrary, the 90 days comes and goes, nobody does anything, but the seller continues to work with Baldwin and Associates, our representatives, trying to get this thing rezoned. We've attached the email that shows although we were supposed to have this 90-day period be over in the fall, they were working with Baldwin Associates in January. The long and the short of it is, Your Honor, my client paid $21,750. This seller, owner, plaintiff breached the contract because the contract specifically says that if my client can't close, then the seller would only take $1,000. Not only is he trying to take all $21,000, but now he has sued my client for $650,000 on top of that and attorney's fees. So they've breached the contract. And again, this is a no evidence motion for summary judgment, Your Honor. We're looking for a scintilla. We have a ton of scintillas just based upon the contract, the fact that this is an owner, seller, broker, the fact that they're holding on to my client's money. He's not allowing the title company to release these funds. That's an absolute breach. He's sued my client for $650,000. He's making my client incur more and more damages and attorney's fees. So I think we have a lot more than just a scintilla, Your Honor.
Your Honor, may I respond?
You may.
Thank you, Your Honor. Your Honor, I think opposing counsel forgets his burden of proof. This is not his traditional motion for summary judgment. This is our no evidence motion for summary judgment. And here, Your Honor, their burden of proof is to point to specific evidence that supports the challenge elements of the breach of contract claim. If you look at their response, Your Honor, there are no specific references to evidence that shows that that supports the second element, the third element, or the fourth element. And in fact, opposing counsel just now argued, facts that are nowhere found in his response. That are nowhere, that are not supported by competent, admissible summary judgment evidence, Your Honor. And in fact, they, if for instance, they nowhere in the response do they say what specific contractual obligation did we breach under, in the sales contract. They don't quote it, they don't recite to it, they don't refer to it, Your Honor. And in fact, all they do is to simply say it's just a long diatribe of arguments that that goes to their affirmative defense, which again, Your Honor, is not before the court today. It's a no evidence summary judgment on their counterclaim. They, nowhere do they state or do they point to evidence, specific evidence that shows that how we've breached this contract or even how we've caused them damages. And in fact, Your Honor, let me share, sorry. Opposing counsel, as mentioned, they don't point to anywhere in their response or to the specific evidence. There's 73 pages altogether, Your Honor, of this motion, including with the evidence. This court, should not be burdened through sifting through 73 pages of documents to figure out, which parts of this response in the exhibit supports the second element, the third element, or the fourth element. Your Honor, they've clearly failed on their burden to raise genuine issues of material facts.
Are you still moving on the unjust enrichment as well, or just the breach of contract?
The unjust enrichment as well, Your Honor.
Okay.
Your Honor, can I respond to that just specifically real quick?
Sure.
Page 14, Your Honor, at the very bottom of the page, one of about 20 instances where we say, as a result, Abdul Hussein has clearly, last paragraph, has clearly sustained damages in that he has paid the option in earnest monies of $22,750 in total, which he has never received back. He has had to pay Baldwin and Associates and try to rezone the property, only to learn that 9202 knew or should have known that this was a fruitless effort because it had been denied in the past. Now he has having to incur additional damages to regain funds that are rightfully his. It's right there, black and white. Additionally, Your Honor, if we're going to talk about burden, I think she's mischaracterizing the law. She is charged with the duty, with the motion that's not supposed to be conclusory in general. She's supposed to identify which portions that she's attacking in this contract. She doesn't. That her motion should be denied on that basis. Then if her motion is, and we've set that out in the beginning portion of my response, if her motion is to be considered, Your Honor, then all I've got to do is come up with a scintilla of evidence on any of these elements, on all these elements, then I'm done. She she's misquoting my burden of proof. The other thing, Your Honor, if you would look at her motion, it's premature because we're not done with discovery. And there's this collusion between 9202, which is the seller, broker, owner, and our own broker. We sent out discovery to our broker, Your Honor, and we got general answers that are not worth anything. 9202 sent out discovery to Ready Real Estate. Then they somehow reach a Rule 11 agreement to pass their answers past my summary judgment deadline to file an answer, because he's holding on to all these documents. Now that I've filed my answer to the summary judgment, I've attached my evidence. All of a sudden, now Ready Real Estate comes up and answers 9202's discovery. Her motion is not specific, it's conclusory in general and should be denied on that basis. Her motion is premature. We're not done with discovery, but she's filed it in a way
Did you file a
to
motion
where
for
I don't
continuance?
get the discovery responses from Ready Real
Mr.
Estate.
Hamada, did you file a motion for continuance?
No, I didn't, Your Honor.
Your Honor, may I respond?
Sure.
Thank you, Your Honor. Your Honor, I think opposing counsel is, I think it's being a bit misleading. Maybe is mistaken by Rule 166A. Your Honor, if you look at our motion, we do specifically challenge specific elements of his counterclaims of breach of contract and of unjust enrichment. We stated, we've met our burden. I mean, we pled accordingly to Rule 166A subsection I. We state here that we challenge, Hussein has no evidence that he performed or tender performance in his contractual obligation under the sales contract. Hussein has no evidence that 9202 Scene breached the sales contract. And, Hussein has no evidence that he sustained damages as a result of 9202 Scene's alleged breach of the sales contract. And before that, Your Honor, we actually list all the elements of breach of contract. So we fulfilled that obligation. Second of all, Your Honor, this argument of how there, reasonable amount of time of discovery has not passed, that's a bit absurd, Your Honor, because they admit in their response, if you look at page 5 of their, page 4 of their response, Your Honor, they admit that they filed these counterclaims against us in December of 2019. They go through all the pleadings and discovery that we've done since December of 2019. And, and here we are now, nearly a day away from September of 2020. On top of that, Your Honor, these new claims that were filed in August, that's completely irrelevant here because those are Ready Real Estate's counterclaims against Mr. Hussein. That has no bearing on our claims against them or their counterclaims against us. And in fact, Your Honor, the parties filed an amended scheduling order recently, and discovery deadline has passed, and they've agreed to that discovery deadline. And that was back in, I believe, in August. I believe it was on August 20th or 21st of 2020, and that's pursuant to the current agreed amended scheduling order. So sufficient time has passed. This motion is properly before the court, Your Honor, and we believe that we've established that we are entitled to summary judgment on their counterclaims of breach of contract. Because again, Your Honor, they haven't, if you look at the response, they don't point to specific evidence. They don't point to specific parts of the sales contract. They just simply, regurgitate their pleadings, and a pleading alone, Your Honor, is not sufficient summary judgment evidence.
Okay, anything else, guys?
And Your Honor, we also move for summary judgment on their unjust enrichment claim, Your Honor.
Okay.
May I argue that?
Sure.
Thank you, Your Honor. Your Honor, they have no evidence to establish one or more elements of their unjust enrichment counterclaim. Your Honor, in order to have unjust enrichment, or unjust enrichment occurs when a person has obtained a benefit from fraud, duress, or taking of undue advantage. There's no evidence, they presented no evidence that shows that 9202 Saeed obtained a benefit from Hussein by fraud, duress, or taking of undue advantage. And Your Honor, on top of that, when there is an express contract, Your Honor, there can be no claim for unjust enrichment because the contract controls. And that is, that's considered the economic, excuse me, Your Honor. That's under, and that's pursuant to Hill versus Shamoon and Norman LLP 544 Southwest 3rd, 724, a Texas Supreme Court case from 2018. There, Your Honor, the Texas Supreme Court stated that under the express contract doctrine, a party cannot recover under an equitable theory, for instance, like unjust enrichment, when a valid express contract covers the subject matter of dispute. And Your Honor, here, the sales contracts clearly states how, how to treat, how to disperse the earnest money that they're complaining about. And Your Honor, they're also being, disingenuous here to say that we're holding on to their money or somehow we have possession of their earnest money. They know for a fact that we don't, that the earnest money is currently with the title company. And in fact, if you look at Exhibit E2 of Mr. Hussein's response, Your Honor, may I share a screen?
Sure.
Thank you. Your Honor, if you look at if you look at their Exhibit E2, which is their letter from February 28, 2019, here, Your Honor, they say that, I think this is evidence, I mean, over here, they said they're not going to attend the closing and that they do not wish to move forward with the sale. I'm paraphrasing here, Your Honor, and that my client, meaning Mr. Hussein, wishes to enact the option clause and be returned his escrow deposit less than $1,000 option fee. Please remit payment to either my office or back to Mr. Hussein directly within the next 7 days. As you can see, Your Honor, the recipients of this letter includes Capital Title, which is a title company named under the sales contract. So it is just disingenuous for them to sue us for unjust enrichment, to allege that we're holding on to the money when it's clearly, and they know for sure that it is with the title company. And for that reason, Your Honor, we've established that there are no genuine issues of material fact for unjust enrichment, and that we're entitled to summary judgment on that counterclaim.
Response?
Briefly, Your Honor.
Yes.
I know you've got other stuff. Just her client, owner, broker, real estate guy is trying to sell this property, which is zoned residential, to my guy, who operates grocery stores and liquor stores in South Dallas, has no use for residential land. Just so you know the background, this contract was negotiated. My guy offered 600 and then they agreed on 650. Three months before, the seller had bought this land for $27,000. 5 months later, selling it for $650. In the contract, Your Honor, they somehow mark out that he cannot sue for damages, can only sue for specific performance. That's why we're here. The real estate agent representing us, trying to supposedly have an our back, tried to get the earnest money released, but there was a lawsuit filed by 9202 prior to anybody doing anything. So title companies holding on to the money based upon the lawsuit filed by 9202. The contract that was entered into between the parties isn't worth the paper it's written on, Your Honor. We'll prove that at trial. Not only is there the seller broker has himself representing my client, but he also fails to disclose that he's a licensed real estate broker, violation of the Texas real estate code. He also has provisions in there where any sophisticated real estate person couldn't decipher what this 90-day period option to terminate the contract. I've asked 3 real estate lawyers and I got 3 separate, different, distinct opinions. The opinion of the court is what's going to count, but that language is hopelessly vague and unenforceable, Your Honor. Based upon everything that we have in our response and the two affidavits, not only do we have a scintilla of evidence that they took advantage of this guy that's got a 6th grade education, but they took him to the cleaners. Not only are they taking his $21,750, but now they want to take $650,000 and they're running up their attorney's fees. They've had 3 lawyers on this file from day one. And so, Your Honor, she's got the standard wrong. She's got the burden of proof wrong. We've got more than a scintilla of evidence. We have enough evidence to get to a jury or to get to you, Your Honor, on October 20th in terms of having a trial on these issues. The summary judgment evidence proves that they took advantage of my client. They took advantage of his lack of knowledge, and they filled out this contract in a way. They had him sign a contract, Your Honor, with no seller.
Your
That's
Honor,
the first contract he signed. There wasn't even a seller identified.
Your Honor, may I? I'm sorry, go ahead.
Go ahead.
I'm sorry?
Ms. Ahmed, go ahead.
Okay, thank you. Let me just quickly respond to his 3 points here. First of all, opposing counsel's statement of how this contract is hopelessly unenforceable, Your Honor, may I remind the court that they want to avoid the same contract that they're trying to enforce against us. Their breach of contract claim is premised on the same sales contract that they're wanting to avoid. And again, Your Honor, this is not a summary judgment, traditional summary judgment on their affirmative defense. This is a no evidence on their counterclaims. Second of all, Your Honor, opposing counsel may not have reviewed the contract, but we did indeed disclose. My client did disclose himself as a real estate agent in the sales contract. If I can just show that to the court, I believe that's on paragraph 25 of the contract. And in addition, Your Honor, that argument that they just made, it's nowhere in their response. If you see right over here, Your Honor, in paragraph 25, subsection I, on page 12 of their exhibit D, it says right over here, license holder disclosure, seller is a licensed real estate. I'm gonna zoom in, Your Honor. Seller is a licensed real estate broker. We made that disclosure, Your Honor. And again, that argument is nowhere in their response. Opposing counsel, is just attempting to bring in parole. The parole evidence rule bars them from bringing, external evidence to avoid, to avoid the enforcement of a contract, which they signed to, which they initialed each and every page. Which they have, which again, Your Honor, they're trying to enforce against us. Your Honor, they haven't produced sufficient evidence. They haven't produced, again, they don't point to any specific parts of the contract, which says, which states that we failed to, that we had to a contractual obligation to do something X, Y, and Z, and that we failed to do X, Y, and Z. There's nowhere. They don't state that anywhere in their response, Your Honor, or produce evidence to that, in support. So, Your Honor.
All right. Yeah. Okay. Thank you. I'm sorry. We're just running out of time. All right. Well, I will take this under advisement. We'll get you a decision within 3 weeks. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, guys. You be safe out there. All right.
You too, Your Honor. Thank you.
Thank you, Your Honor.
I'm trying to stop participant sharing. Can you, Ms. Ahmed, can you hear me? We're frozen. Is everyone here on the Krapau versus Combs case?
Yes, Judge. John Galini for defendant.
Logan
All right.
Despain on behalf of plaintiffs.
Okay, great. You guys ready to get started?
We are.
Okay, let's go and get started.
Judge, we have a motion to compel here. This is a breach of fiduciary duty case in which the plaintiffs need the financial records from the defendant going back to 2004. We originally made the request for these documents in April of 2019. We filed our original motion to compel in December of 2019. We were working with counsel for defendants plural, and there was a motion previously set for April. We reached an agreement at that time. We received a few documents from them in May, and when I say few, I mean very few. But since then, we have received nothing further. We're seeking the bank account and other financial records listed in our motion on pages 1 through 2, A through P. And we need those documents in order to move forward. So we're asking for the court to compel those documents to be produced at the hearing today, as well as to reward. Well, let's start with that, Judge.
Hans? Mr. Galini?
Yes, Your Honor. Your Honor, A through P on these were the same things that they included in their previous motion to compel. We have provided either why we do not have possession of those documents or those documents to counsel previously. And whenever he says documents haven't been provided, we've provided thousands of pages of documents thus far. And in response to my conversation with the previous counsel, Joshua Carpenter, who's the only person I've ever conversed with. This is the first time. I met Logan on Thursday at a mediation attempt. But on A through P, we've either provided those or they are not in the possession as we previously stated. There is a long line, I guess, requested for documents since it's all the way back to 2006. And my client has scoured, provided everything possible. We've also made it a point to allow or to advise plaintiff's counsel that if we come into any more documents, that we certainly will. He's scoured every old computer, gotten copies of everything. We've provided almost everything on this list has already been provided to them. And there's copies of emails or conversations where they have been provided to them, Your Honor. So most of these are actually moot points. And I've advised them previous to today that they are, and invited a conversation to try to see what they're still thinking that we are lacking. And those fell on deaf ears with every attempt, including before this amended motion to compel was filed. There was certainly never any conversations between us. The last one was in April, before the last motion to compel, wherein Mr. Carpenter and I had agreed on everything. We actually went back through and found some additional documents and provided them promptly. And the last group of documents, probably well over 1,000 pages, was produced in May 19th, which were some copies of checks and things from some accounts. This is actually a son that.
So let me ask exactly, Mr. Despain, what exactly do you think is missing?
Well, many of the years of these documents from these accounts we do not have. He's correct. We received a few documents in May, but it wasn't even for the years we had agreed upon. We stand by this list that we gave the court, A through P, that we still need as documents, because we filed this motion after we received those supplemental responses in May, which were 2 emails. That was it.
Well, the 2 emails had multiple, and when you say a few documents, they had well over thousands of documents.
But they were from 2 accounts, and we have a list of, I don't know, 20 accounts here. So we're still 18 short, even if those were. But I know, for example, one of them was Wells Fargo, and it did not encompass the entire time period. Bank of America, excuse me, Bank of America.
Thank you. Part of the problem here is we have told them that we will provide everything we can either get our hands on or that we have in our possession. And first of all, due to retention rules and the fact that my client did not at some point believe that he'd be needing to keep records back to 2006. Some do not exist, and we have advised them of that from the beginning. Your Honor, if you do look at the first page of their motion to compel again, number A, we contend that that's been provided. B, we told them already that there's none. That's actually an account for something that has nothing to do with this account. This was a home that my client has that has nothing to do with this. We've already advised them of that. Number C, we've already advised them that they were even unaware of what that is. And D, that has nothing to do with this. However, we have provided them with some of those records, and these were never even requested. The Berkshire account in E, we've already told them that we don't even have a clue what they're talking about. What happened is my client cared for his mother's, some of her banking, and assisted her with it for many years, her mother and her father. He didn't exclusively deal in their dealings. And that's part of the problem here is I think they want things that my client has never heard of on some affairs. We've given them, and we contend that we've provided them with everything that we have been able to either provide, have in our possession, has to do with the mother or my client and the mother. And we contend that we have provided them with any other document we've come in contact with since that time, and will continue to do so. They want a legible copy of a receipt for one golden coin. We've provided them with the only copy of the receipt that we have. We cannot make it more legible than it is. So basically, they're asking the same question that we've responded to and hoping for a different answer. And so we commit to do everything we can. We just can't produce items that we're unaware of or that did not exist as far as to my client's knowledge, and that he never had any active or passive involvement with.
Judge, if I may briefly respond. We have sent out subpoena requests, so we know that many of these accounts exist. But at the end of the day, here's what we would ask the court. We'd either like these documents produced, or we'd like them on the record saying they have produced everything we've listed. And from that moment forward, they cannot produce anything more in this case. I think that's as simple as it gets. And so they either put up or are done at this point.
That seems fair.
Your Honor, when we're going back this many years, though, if we do come across something, I don't believe that to be fair. If we'd held back something that was already in my client's possession, I totally understand that. We've done our best, but I can assure you that within
So obviously, there's already been a motion. We're here. You guys have done your due diligence. I mean, at some point, I agree, you kind of have to put up or shut up. So,
Your Honor,
you guys.
You've extended the discovery deadline until mid-October. And so I would at least request that we have till mid-October. I don't believe there's any. And my client, we've gone over this list a dozen times. We don't believe we're missing stuff, but my client went back into another old computer, though, and actually did find stuff in May, and we produced it immediately.
And Judge, we would say they've had a year and a half. They didn't even file a response to our motion to compel. We would just ask that the time has passed. We would ask for a reasonable time period to produce it. And if not, they're barred from supplementing any further previous requests on our discovery requests.
I mean, at some point we have to cut this off. So why don't we?
I'm fine with that. If you'd like to give us 45 days, if we can't produce and shut up, we'll shut up. We're fine with that.
When's this case set for trial?
Maybe if we get there, it's in January.
And Judge, we would request 15 days. Again, they've had a year and a half. We've already tried mediation without these documents to no success by either party. So if we're going to try mediation again, we would ask for a more reasonable request.
Right, 15 days seems fair. So court's going to go ahead and order that all documents that are responsive need to be produced within 15 days. Failure to respond within 15 days will result in those documents being excluded in trial absent good cause shown.
Your Honor, as far as the ones that we've got objections to, we've never even had a hearing on the objections yet, but we will produce like we'd have before. But, you know, as far as
I thought there were no objections. Are there objections?
Oh, absolutely, Your Honor. Timely objections. But we still have produced, so that's not an issue, and we'll continue to produce, but we would still need to have a hearing on even whether those are going to be admissible for trial.
Do you want me to rule on the objections or not?
I would wait at least the 15 days and see if we can work it out, which is fine. The objections aren't before the court right now, and so yeah, I would ask.
They're not before the court, okay. Is that correct? They're not before the court?
Logan?
Did you file a response to this motion?
I did not.
Then I am not aware that they're before the court, but he hasn't brought them to the court's attention either.
Well, they're not an issue yet. Like I said, we may have to.
But what we're asking for is either 15 days to do the documents or they're barred. Then we can deal with the objections at that point, I guess.
That's all I was saying. That's fine. I have no trouble with that, Your Honor.
And Judge, we would just ask that the attorney's fees we've requested be reserved for final as well, if the court would allow it.
A reserve ruling on attorney's fees. Anything else, guys?
We did also have basically just a motion to quash and depositions. The date's come and gone. I've requested from counsel a few times to get other dates and to work that out. Counsel, if you'll represent on the record before the judge that you will work with me on dates, then I will pass that if we can work that out together.
That's fine. We agree.
He is new counsel, and so I'm going to give the benefit of the.
Josh Carpenter's still on the case. I'm filling in for him today. Had a medical. I'm sorry?
Yeah, email Thursday, he told me, or Wednesday, he told me you were taking over the case.
Well, I'm with his firm.
Okay. So, Your Honor, hopefully we'll be able to get that worked out.
Great, guys. Just get me an order on all this and we'll take it from there, okay?
Thank you, Your Honor.
Thank you, Judge.
Thank you, guys. You have a good day.
May we be excused?
You may.
Thank you.